Hi there, it's Terry Bell from Bell & Company. A second part of our webinar series we're doing on the very sexy subject of bankruptcy. I say that tongue-in-cheek, it's what we do day in, day out. So we're going to kick off at 1 o'clock here, but we're just waiting for a few more people to join us. Just as a precursor, we're in a position now where we're finding that things are opening up in every sense, as indeed does the threat and spectre, if you like, of bankruptcy. So that's why we're bringing this forward. And to sort of give information, yes, we're doing it as a promotional side for sure, but anything or any questions that stem specifically from this webinar, we'll entertain on a completely gratis basis. We're just trying to put a bit more out there in terms of what is a sort of pretty unspoken subject, really. And there's an immense amount of BS out there about bankruptcy. The number of people that know about it but have no idea about it really, but they have an opinion on it. I say we do it day in, day out. It's what we do. We deal with bankrupts, we deal with trustees, and we deal with the official receiver every day. So I'd like to suggest that we may have an idea of what we're talking about. So what we're going to do here is we'll crack on now as 1 o'clock has sort of come and gone. So because there's quite a bit to go through. In the last webinar, we looked at the fear of bankruptcy, eradicating the fear of bankruptcy. Easy to say, hard to do, but it hopefully gave a bit more context on the subject. This one, we're looking at the process. We're not going into the minutiae of every part of a form we have to fill out. We're giving you the overall perspective of what's going to happen through here. And in fact, it's literally just come to me then. One bit we've got to add on at the end is the discharge from bankruptcy, which is very, very important, but we'll maybe cover that on another day. So I'll click it up. I'm going to use a PowerPoint just to help me, if nothing else, but hopefully it gives you as a footnote to the discussion we're having here. So we'll crack on, and this is the contents that we're going to go through. So we're pointing out that it is a legal process, be it a debtors petition or a creditor petition. We're also going to have a mini advert, if you like, from our COO, Angela Thorpe, who's going to give you a bit of a backdrop on what we do. Then we finish off, we go to creditor petitions in detail there, what's going on there, the involvement of the official receiver and what their role can and can't entail, assets, always the principal thing that's at risk. They're what's got to be realised for the creditors in whatever way that goes. There's a little bit of information about our SME book. There's a copy of it on my left shoulder if that works. A bit more about the trustee, or what should be known as your best new friend should you have the misfortune to go bankrupt. And then we're giving you a bit of a breakdown. As you can see, every case has the same process of slightly formulaic, but everyone is different. And then we're ending on a couple of useful contacts if you want them, if you want to go out and look at what the government say, the insolvency service. Not too useful, but it'd be remiss of us not to give you that. So we'll kick off. So we're looking at a legal process here. It's a court order. Ultimately, there will be a case number. There will be a process through the courts in whatever form it is. But it's important to understand that that's how serious this is. It's not an agreement to do something. It's nailed. If you are bankrupt, you're bankrupt. Here's your court number. Here's your bankruptcy number, and it carries on with you through whatever way the process takes you. So there are two routes to it, which we discussed briefly in our last webinar. There's a debtors petition where you decide to avail yourself of the insolvency laws to protect yourself from your creditors. Okay, this can take many different forms that you want to protect yourself. You may have had enough of all the pressure. Sometimes that can be quite threatening, and we've seen it get really nasty in instances. And it also helps bring finality to what can be something that's dragged on forever. There's one of the examples here that comes up where somebody said, when we first met them, there's no way I can go bankrupt, absolutely no way. But after time, it became more and more apparent that he had to go bankrupt because of the enormity of the debt and also the pressure that came with it. And we try and put that across early to clients. If we think, in our humble opinion, that clients should look to petition for their own bankruptcy, we'd make less money helping somebody through that. But if it's the right advice, that's what we give them. Flip side of it, of bankruptcy, is you're looking to shake money out of somebody that owes you money. If you're owed more than £5,000, then you can start the process here if you believe they have assets. It does a thing of flushing somebody out who may be trying to hide behind the law, their solicitor, whoever and what. It flushes them out to make sure they do pay attention. and is, like I say, in terms of finality on debtors, this is very final this side. This is a creditor's petition, and it's very important to keep that level of commerciality. If out of an act of you feel you should do this, possibly a bit of malice to just definitely bankrupt somebody, cool, if that's what floats your boat, do that. But in most instances, you're looking to shake it out, and let's keep the commerciality in mind, because as we explain a bit later on, if you do bankrupt somebody, you actually lose control of the carriage of that case, as we say. It hands over to other people to report to you. So just keep an eye on that. So firstly, we're going to look at the debtors petition, where somebody looks to declare their own bankruptcy, essentially. There's an element of control here. You're not waiting for something to be done to you. You're actually getting on with it and bringing that finality, using that word again, bringing finality to what is undoubtedly can be a protracted and difficult time for you and your family. There's no two ways. You can't hide that. If you have hidden it to this point, you'll be feeling all sorts of guilt, remorse and the like, but the finality in every sense brings an end to this difficult time. And if you do petition you for your own bankruptcy, you are looked at differently. The official receiver definitely looks at you because you've taken control of what your position is and you brought it to a head. If you are bankrupted under a creditor's petition, basically they look at you on the basis of get yourself here, what have you been up to? So there's that side. Also, people suddenly realise you were in a difficult position, say, not necessarily family, but friends may say, gee, I knew you were struggling, I didn't know it was that bad. And again, you've got the control of the process, and straight away you take the pressure off. Okay, there's different pressures come to bear, sure, but if you've got 12, 20, 50 creditors shouting at you, this brings an end to it. And under statute, your creditors cannot contact and harass you. They have to go through the official receiver and or the trustee. So this is not an easy decision, but let's look at the benefits of bankruptcy, if you like. It just gets you away from where you were. And then there's a lot spoken about mental health and the like in today's world. Sure, it exists. Never underestimate the immense pressure that business women and men feel, especially if they're exposed, to any threat of bankruptcy or other court actions. And again, it's about commerciality. Sometimes we'll give a very quick example here where somebody owed, say, £500,000 and they had £200,000 of equity. There's only one issue, dealing with a trustee and your £200,000 of equity. One and the same thing, because he or she will own your interest, the trustee that is. Okay. And again, never underestimate the pressure that this brings. Debt pressure is 24/7, very cliched, never goes away. You may live a life of the fascia may be great, but behind it, if you've got the debt pressure, it's there forever, and it has to have an effect on you. There's no two ways. And worse, in my eyes, if it starts having an effect on your family and your loved ones, that's when you've got to make the right decision. And that's not pushing it down any sort of way here, but that's the way of it. People are very different as to how bankruptcy affects them. I've seen people come out and have huge remorse that they've let themselves down, their family down, and everything they hold dear down, whereas others see the massive release. I've seen somebody come out and do the Eric Morecambe click in the heels in joy, because they see that end to a difficult time. And it then goes back, I keep using this word finality, but it brings you back to basics. Okay, you may have had 20 pieces of debt you had to service, including your car, including your home, including whatever, holiday home, whatever. Finality brings you going back to basics. What do I need to do to survive? Can I save my home? Can I make sure I earn enough income to care for what I've got to do? It's not the frivolity, if you like, of some of your debt goes, and it brings you back to basics, which sounds a little bit patronising, but that's what sometimes we all need. You've got to go back. I, for instance, did a video where I said when lockdown came first, I just checked my finances and went through, sacked bloody a couple of subscriptions which I never took up. And this is far more serious, but it's that sort of thing. You go back to basics. What have I got to do to survive, and how am I going to do that? Then we're looking at the other process, legal process available to creditors that are owed money, and that is a creditor's petition, But first and foremost, you need to issue a statutory demand. It's not a case of just issuing a bankruptcy petition. Now, a statutory demand can be issued to anybody that owes £5,000. Now, again, we keep going back to commerciality, finality, etc. But commerciality is everything from here on in. And you need advice, but ultimately you've got to give instruction, decide how you're going to deal with the matter. So a stat demand is served on somebody and it has to be done correctly, it has to be completed correctly, obviously, because if you leave doors open when it comes to the potentiality of the creditor getting the stat demand, they may be able to set that aside, even if it's on a technicality you didn't get right in the form or it wasn't served correctly. So stat demand arrives, it's served, deemed to be served on the victim, the target, if you like, and they have between 18 and 21 days to either resolve it, pay it, and or set it aside. If they choose to ignore the stat demand and just think they're just making lots of noise, you then have the ability to bankrupt that person. You must issue a petition, but you have that right now to get on and petition for that person's bankruptcy. If that petition is issued and the costs that go with it, which we'll come to in a minute, then a court date will be set, and then that person has to defend themselves. They still have the audience of the court and they can appeal against it, etc. It's a lot more difficult for them if they've chosen to ignore the stat demand. So again, we come back to that commerciality as I keep talking about. Is it the right thing to do? A little bit further on, I talk about the emotions of it. This is an early stage. This is the statutory demand, and it's very good for rattling somebody. You're trying to get them to engage with you. Very often, we do a lot of work here in Belfast with all the banks, and that's sometimes their preferred course of action, and it brings the party to the table. If the client has ignored them, been rude to them, the usual things there, and they want to try and get some sort of conclusion to all this, they'll issue a stat demand so it makes sure they engage, because if they don't, the door is open, as we said there, to bankrupt somebody. Another consideration in the commerciality, this is a long haul to recover money if you do bankrupt somebody. And most importantly, to my mind, is that you lose carriage of the case. If you bankrupt somebody, the trustee and or official receiver now controls their lives. They're almost, the debtor is almost third person removed, and you're after them, but you're now dealing with a trustee. As the person that may have petitioned and secured the bankruptcy, you have some input and you will receive your costs back, but now the trustee or official receiver is acting for all the creditors. So say you're owed £10,000, suddenly all the credit cards come in, all the rates bills come in, contingent liabilities like personal guarantees will come in, everything comes in there, any debt and asset, but any debt foremost. So suddenly your £10,000 can look fairly inconsequential, the example I'm giving it, given the enormity of all the debts when the music stops. If that person is a sole trader or a partnership in the business, obviously those debts would come into the bankruptcy. So you're looking at those three elements of the commerciality of what you're trying to do. First off, it's a long haul. Sometimes it can take over 3 years, and sometimes the return is pretty minimal. You lose carriage of your case. There could be other routes you could take, like securing a judgment and a charge on a property. And ultimately, what is your return? It's totally out of your hands. It's down to the trustee, A, what he recovers, and B, what he or she then charges. So it's all these parts have got to be considered. And you've got, as you ramp your action up, so you've got your stat demand correct, maybe, get that right. That gives you a chance then to move to the next stage. But another decision must be made in terms of commerciality. You're definitely going to need court representation, and you're going to, obviously, the costs that go with it, and there are petitioning costs, which aren't for this video, but we can find that out from anywhere. So it's good, you've given them a rattle, but you've got to make sure you're making the right decision for you. Just in this next thing, what I'm going to do is going to play a quick sort of promotional video, if you like, of us at Bell & Company by our COO, Angela, who's going to sort of tell you more about what we do. So yeah, a little bit of advertorial, but hey, this is what it's about. We're all trying to procure business. These sessions with the bankruptcy webinars are to impart knowledge. in an overall sense, not the specifics, because there's a lot going on in bankruptcy. As we come to the settlements in a while, I'll reflect on that they're very individual. The same but different, as we always say. So Angela's now going to say a few words, and then we'll pop back on and start going into a bit more detail of the creditors petition.
Hi, my name's Angela Thorpe and I'm the Chief Operating Officer here at Bell & Company. We here at Bell & Company are debt strategists, and what that means is that we deal with both pre- and post-insolvency advice for both businesses and individuals. What makes us different is that we actually have varying degrees of specialisms here in-house. So we have people from insolvency backgrounds, legal backgrounds, accountancy backgrounds and financial services backgrounds. And we take a very collaborative approach to make representation on behalf of our clients for full and final settlements with creditors. My team love what we do here because we see the life-changing results that we get for our clients on a daily basis. Thank you. So
that's Angela telling about what we do. It's a strange world, how we all make a living. We're in a particular niche, but we're pretty busy at the minute, and we're waiting. Unfortunately, the world's going to get slightly madder and worse when we get through the COVID. It can leave quite a few victims. We've got a team here and in Leeds of about 25 people working away diligently in terms of what we do. So we like to use the adage that we're big enough but small enough to care. So advertorial over. So the stat demand's been correctly served, presented and everything else, and now you're in a position they've either failed to address the stat demand, or if they've applied to have it set aside, you've won that argument as well in court. And again, you'll need representation at that stage, and you, again, going back, be careful where the costs go here. So moves on to the creditors petition for to bankrupt somebody. Again, it needs to be served correctly, it needs presented correctly, it needs to be drawn up definitely by a solicitor. You're trying to cover as many bases as possible, so there's no wiggle room. You've now got, if you're trying to rattle these people to get money out of them and you think they've got money, that's another point, and then what you're trying to do is rattle them to get them to a place where they will engage, they will make efforts, they will get you money and pay what is due to you, quite rightly due to you. Again, this is a court hearing, it's a legal process, so at this stage there will be a hearing and a hearing date will be set. You will definitely need legal representation. You can do it yourself, but it doesn't, in our opinion, in the main work. So just build in that cost, the petition costs, legal representation costs, and that's very much dependent on the complexity of the case or otherwise. So, but just get all these things lined up and know what you're trying to do here. Use the phrase there, is it too strong a lever? Now, this is almost like the antidote to what we said in terms of a debtor's petition, in terms of eradicating the fear of bankruptcy. It can be a lever to get settlements on agreements if it's properly explained where bankruptcy might take somebody chasing money. The other one here is, to use another cliche, sometimes you can be a sledgehammer to crack a nut. And by that I mean, is it really necessary to follow this right through to the end? If it is, and it is the ultimate sanction that's at your behest, if you're owed money, then sure. But again, just be careful of how much you need to do here. Could you get a countercut summons? Could you get a default judgment? Can you get an order charging that? Can you get security from them on an informal basis while they sort this out? A few things to look at there. The other thing to note is, if you issue a bankruptcy petition, that goes on credit files and on the bankruptcy register straight away. And what that can do, that can limit what the target can and can't do, which may be a good thing. If they're trying to sell a property, say, in the meantime, and salt away the funds out of the way of their creditors, it's there to stop a solicitor affecting any such sort of transaction. So by that, what you're trying to do is make sure you ring fence, if you like, anything that's going on. Flip side of that is the creditor, right, is stuck. The debtor, is stuck and cannot raise finance because the credit rating will show it. Any bankruptcy search will show it. And it's very difficult to align it, to release that person from that restriction, if you like, against go out and get the money, let's sort this out. So again, it needs to just be known and considered. If we do this and issue the petition, you've either got to follow through the bankruptcy or you may limit their ability to pay you. So you get your day in court, the judge agrees to what you're saying, and it wants to make sure you definitely want to bankrupt this person, and you do, what then? Well, ultimately, you will have your costs paid first if there are assets within the what's called the bankruptcy estate. Bankruptcy estate covers all the assets that person may have and all the liabilities. The official receiver and trustee's job is to get those aligned and get the maximum return for the creditors. Very important point, very often ignored. So you would get your costs back. You will also get a percentage return. Again, it depends what you're triggering here. If you've got a £10,000 debt, but the bankruptcy will trigger, I don't know, a claim on a personal guarantee for 500,000, then you have to look at that dynamic. Your debt shrinks as a percentage of the overall estate. And the other thing is the time scale involved in here. Very often, when assets are, in all cases, when assets are involved, the trustee has 3 years to realise them, sell them, get money for them, whatever it is, okay? So it can take up to 3 years' time. And you've got little or no idea on what you're going to be getting back. So again, it's just, you might say, right, well, I expect 50% back. You may expect it, but it may not be what's secured. So, and 3 years, as we all know, is a bloody long time in business. And we see any number of instances where people have bankrupted somebody thinking they're going to get a lot of money back and end up literally with diddly squat. We've seen somebody who was owed 75,000 thinking they were going to get 40,000 back out of it, ended up after costs and everything else and limited realizations of 2.5 grand. So it's very, very, very important. Last point, which I repeated many times, commercial decision only. The point above, try and keep out emotions and personals. If you do, you're spending good money after bad. If you feel that strong about something and you definitely want to, no matter what, bankrupt this person, and you have the right to do it if you manage to establish that they do owe you money, then that's okay. People have different agendas. But if it's down to pure commerciality, he may have called you names, she may have shouted at you, whatever it may be, keep it on the money. So that's how creditors petitions, the process pans out. The next stage then, so our target, I'm going to keep calling the target, then I won't mix up with debtors and creditors. The target then has to liaise with the official receiver. The official receiver is part of the insolvency service, obviously the government organisation that checks all facets of insolvency, be it liquidations, administration. They have an overall umbrella where they're looking at everything. Their mainstay is personal bankruptcy. That's something that always falls in at their door, and they're looking at it from there. So when this person is bankrupted, they will then be contacted very quickly by the official receiver, usually within a day, because they want to make sure what is out there so it doesn't get frittered away. The 20 grand in the bank account isn't suddenly in their Paddy Power account or anything. Stupid example, but they want everything gripped. They don't want the Range Rover going off the drive and the number plate changing, so that's their job. Now, if a debtors petition has been filed, then you've made a lot of representations already, and you've already explained things. Very quickly after that, be it a debtors petition or a creditors petition, there will be a phone call, as I said, from the official receiver to establish what available assets are kicking about, usually focusing on the short-term assets, if you like, of cash and cars and anything else that can move that can quite easily be cashed. Very often, your bank account is immediately frozen. Sometimes they get the odd instance where it's not, but very often it is. And then credit agencies are notified as well. So if you're a director of a company, that will come out and have some sort of ramification on your company account as well. That the company's bankers will be contacted so they know what's going on. And again, that causes sort of, we call it logistical problems, because bank accounts are a pain in the backside when it comes to sorting out in bankruptcy. We gave a little bit of advice on the fear of bankruptcy, the fear and trepidation of bankruptcy before. Bank accounts are very awkward in bankruptcy. Some banks don't do anything, a lot freeze them, a lot close them. So you've got to know the ramifications of that. So that's what's going to go on there. So if you're issuing a debtors petition, you'll have prepped yourself well there. You'll have got yourself a little bank account ready to go, and it's where the wages can go, whatever you've got to do to live going forward. Creditors petition, like I said earlier, you're definitely looked at differently. The official receiver may deny that, but it's nearly an instance of, like I say, come here, what have you been up to? Whereas debtors petition, you're nearly deemed to be responsible for your affairs, you've taken the right decision, you've considered your lot, and it's the best thing that could happen here, etc., etc. Creditors petitions, it's almost like, what are you on with here? What's going on? Okay. You will then receive either online or in the post a booklet basically to complete, detailing all your affairs, and that covers your assets, your liabilities, your income, your contingent assets such as life insurance, such as your pension and things like that. And then what they're trying to do is establish a position of where you are in terms of your overall perspective. And in an incomplete way, they're trying to establish a profit and loss account, i.e. your income and expenditure, and a balance sheet in respect to your assets and your liabilities. So that's the role there. And what the forms are quite rightly designed in such a way to eke the information from you. So have you been divorced in the last 5 years? Have you transferred any assets in the last 5 years? There are slightly more complex rules in there, but what they're trying to do is find out the narrative. What has gone on here? And you get a page to say, right, I went bankrupt because, and simply writing the recession doesn't cover it. You need to say, the working capital tied up, I took some bad debts, etc. And again, what you've got to be careful here is you must make sure you fully engage with this process. No lies, because you're signing this document and or in your debtors petition under the Perjury Act. Okay, I mentioned it earlier, and it's very important to make sure you don't perjure yourself, because that's a completely different ballgame that not even we can help you with. That's time off in front of a judge, and you can get yourself basically locked up. So keep an eye on that one. And then, so once the official receiver's gathered the information you've given them, they may ask you to come in, at which point they're looking for a full narrative. They may ask you for a full narrative on the phone. At the minute, they're not too office-centric is the polite phrase for civil servants at the minute, and they will then decipher whether you have what's your net asset position here. Is there going to be any free cash in here? And the rough measure is around £15,000. If it's less than £15,000, then the official receiver will in all likelihood look to keep the case, because it's not really something they put out commercially. It goes out commercially in the main if it's greater than 15,000. And that 15,000 can be made up of the value in the home, the cash, the cars, the net asset value of the business. They take that view and basically they try and get it off their desk if it's a bit complex and there's things to do in it. And that's the role then of the trustee. So the official receiver is that conduit, if you like. You've gone through the process, or you've been put through the process. You land with this man or woman, they work out what you're up to, what's going on, warn you within an inch of your life, don't perjure yourself, come up with a situation and decide, is it for them to keep or is it going to go out to a trustee? So next stage, we're going to look at assets in bankruptcy. Now, the official receiver or a trustee are essentially there to maximise the returns for the creditors, right? Something I'll keep saying, but it does need reinforcing. So that will most likely involve the realisation of what they see are, say, fixed assets, your home, your buy-to-lets, potentially a business, potentially investments, etc., so that they can start drawing down and turning these basically into ready cash. Because in most instances, they start from a pot of zero. And when you've got a trustee appointed, then it's very important to realise they are looking to cash quite quickly, because they need the fees. They're charging hourly rates of whatever, which sometimes can be crazy, but they've got to do it. But that's what they're looking to do. So we've got to make sure we've got that covered. There are very detailed sections in terms of the booklet and or the online process where you've got to detail all the assets you own, particularly keen on property, because usually that's where we have equity and stuff like that they want to free up. Other properties and any investments, like I said, so you've got to get those freed up. Then they look at business assets. So if you're a shareholder in a limited company, your shares will have some value. very hard to assign, but it's a very specialised area. Not to get too hung up on terms of what we're discussing here, because again, this is the process through. They would look at two sort of strange areas. I say strange, and they're still nearly the eye of the beholder. You have chattels and pensions. Chattels typically are your fixtures and fittings, the furniture that surrounds you, the TV and stuff like that. If you have a chattel, such as a Ming vase, I always give this example, that Ming vase, say it's worth 50,000, will be taken by the trustee and sold to realise cash. He then has to provide you the money to buy. If you've got a 4-foot Ming vase, he'll give you 50 quid to go down to IKEA and get a 4-foot vase to replace the hole in the carpet or wherever it's at. So that's chattel. But chattel's normal course of action is everything around you. Pensions, another grey area in that you've got cases for and against pensions being susceptible to bankruptcy and bankruptcy estates. The cusp seems to be around that ability for people to take their lump sum, so from 55 onwards. And there are a couple of cases for, a couple against in terms of whether they should be in or out. We take the view and strongly enforce the view that pensions aren't up for grabs, and it's how you power that through, but a grey area at best. Also, you've got to reflect in their partners, wives, husbands' interests in what they should have, right? Usually, if you own a home, it's shared with the husband and wife, partners, whatever, and both parties are on it. It becomes trickier when the mortgage was taken out in the wife's name because she had a better credit rating at the time and things like this. And it can get a bit ugly in those sort of cases there. But essentially, your partners, husband, wife, whatever, interests have to be reflected when you're looking at asset realisation. You also need to keep an eye, although it's not necessarily for you to keep an eye on, but you need to be aware of keeping a control as well on the costs of realisation. And sometimes our insolvency practitioner friends can get overzealous appointing solicitors, agents, selling agents, etc. So just keep a little eye on that, because at the end of the day, it's going to potentially affect who's ever trying to help you out of this situation. So it's a bit of a minefield. All of these areas here, we're just trying to give that overall process. Like I say, each and every one of these points and others spring off, and they could be something else. Could be their own issue in their own right. So that's assets. What I'm going to show you next, one of my colleagues is just going to pop up here, and you're welcome to it. We've written a small book basically for SMEs and how they're trying to get through the pandemic and all the issues. And you're welcome to it. If you want an ebook, drop us a message. If you want a hard copy book, I always say, in case you can't sleep, it's there and available. I would add that there's a glossary of terms. We try to write it in a lighter way, as sometimes we do with these debt subjects, and with a glossary of terms which are basically gallows humour. And if you are of a nervous disposition and aren't too fussed on profanities, not for you. But if you want to see a little bit of insight how we sort of cover the pressure, if you like, of our work, go to that section. But that's the book there. If you want it, you're very welcome to it. And to say, I don't think it's a hard read. I think it's 60-odd pages in it, and a couple of examples of our work. It's got my favourite deal in it, which is not the biggest by any stretch, but it's still my favourite deal we ever did. The trustee. So if you have the misfortune to be made bankrupt and you have discernible assets, definitely in excess of 15,000, a trustee in bankruptcy will be appointed, who is nearly always an insolvency practitioner, and he is appointed by the official receiver. Says, right, there's one for you, looks a bit tricky, more than 15,000, off you go. And then ultimately that trustee has to report back to the official receiver. Now, it's very important that first line, treat as your new MBF. Obviously, I'm down with the kids. MBF is your new best friend, okay? These people have a job to do. Sometimes they can be, anyone can be a bit objectionable and everything else. And I'm not saying you have to doff your cap and yes sir, no sir, but let's try and get on with them, right? It's tough enough. It's a nasty carry on. You've got everything under threat here. Make sure you give your best chance by at least being civil to these people. If they want to be a pig or ignorant or whatever, cool, do what you've got to do. But my suggestion is you get on with them. And like I say, they have a job to do. If you have hidden or still continuing to try and hide things, do so at your peril, we say there, right? Back to the Perjury Act, back to undermining everything you're trying to do with their new MBF, because you're trying to keep it on a level of trust. As soon as you get to loggerheads and neither party trusts one another, and thus our very existence, then you go nowhere, but the costs go up. Very, very important to try and create some rapport here. Flip side of it is, keep an eye on their costs. It's not for you to necessarily comment on, but you do want to keep an eye on the costs, because it's going to make sometimes your ability to sort something out ridiculous. We had a case that somebody came to us, they've got about 150 grand of equity, and when they came to us, the trustee, who hadn't done a lot of engagement with our client anyway, but he'd searched everywhere around the world, and someone had given him a heads up that our man was worth a fortune. He said he wasn't, and they had nearly 100 grand of costs racked up, which goes on to a point I'm referring to a little bit lower there, in that you can get litigation funding. But we keep on pitch here, just keep an eye on where those costs go, because and I say this, sometimes they're just a little bit keen to appoint legal representation. Sometimes it's needed. If somebody's going to mess about, somebody's going to hide things, lie, everything else, then you need a legal representation, because it's not as though they've not been warned. If you've bankrupted somebody that, we're coming for you, if they start messing these people around, then they have the duty, they have every amount of statute behind them and every right to do what they've got to do, and the court will undoubtedly support them if the judge thinks in any way that the bankrupt is messing about here. So it's very important there to make sure you keep an eye on it, but behave as well during the process. If we had three instances now this year where we've come across cases that involved litigation funding. To give you an example of it, but I'll return to the subject, as it were. At the weekend in the FT, there was a case where a lady was divorcing from basically a Russian oligarch, and she was awarded £450 million. Now, a case like that, there are obviously a small bank of QCs, a room full of barristers, solicitors, everything there, huge cost base. Now, in this instance, the litigation funder, I think it was Burford Capital in this matter, they supplied all the fees to make sure this lady had a good representation, and more importantly from their angle, because commerciality comes in again, that they would win and get a return on the costs that they'd advanced all these professionals. Now, the reason we come in here is we've seen a couple of cases where old liquidations that were put to bed and sweaty boxes 5 years old have reared their heads when they've been revisited. So if you had a company you thought a guy had put to bed nice and quietly and everything was good because there were no assets, and so consequently you were, say, for instance, able to hide a director's loan account in there, they're coming back out with litigation funding. Insolvency practitioners are being actively pursued, saying, look at your old cases. Do you think there are assets that you could have got out there had there been a bit of funding around? And it's going to be a huge thing going forwards. You've got Manuelect Partners, Burford Capital, and any number of funds sprouting up in this field. So the trustee's got another huge lever. If you decide to mess around and he thinks, the bankrupt thinks he can starve them of fees, they can go to litigation funding, and you will be paying the costs, plus you'll be paying the premium on the costs, because they have to win. So consequently, be very, very careful. So as a little bit of a conclusion in terms of the process on trustee, work with them, but be aware of the parameters that they should be working in. And the reason I say should is sometimes you get trustees very powerful in what they're doing. Sometimes they're not, they're prone, to just go a little bit outside their remit, and some of them let themselves down, is a basic premise on there you want to think on. So there's the trustee, that's what we're talking there. Then what we're going to do is end on we've got three examples here, right? And you suddenly see the different dynamic, hopefully, and what can go on this. So there's a couple of debtors petitions here, and then there's a creditors petition. And it's looking at the C word again, commerciality, how it panned out. In this first instance, we had a builder who had a share of equity in his house of about £100,000. Shared with his wife. 200 equity in total, his half, her half, right? Okay, simple. He had great builder, couldn't really organise a big drink up in a brewery, is the polite phrase, and got himself into a bit of trouble, cash flow tightened, but over the time he developed lines of credit with 6 peer-to-peer different platforms. There are hundreds of the buggers out there, and PGs on them all, and they total £350,000. Now that's pressure enough, because that was £10,000 a month to meet those, roughly £10,000 a month to pay those off. Now he took a bad debt, struggled with it, just put literally his head in the sand, excuse the pun, and just could not deal with it. It's far too much pressure for him, right? And we're all built differently. This wasn't a judgment on him. And we said, right, look at Debtors Petition here, right? You're worth 100,000 and you owe 350. Okay, and then it was the shame and what would the family think and all that. And it took a bit of working for him to get it, but it was the right thing to do. If you cannot take that pressure, avail yourself of the law. That's what it's there, to protect you from your creditors. Eventually he got his head around it, and I wouldn't say it was the best day of his life, but the relief was palpable. And he went bankrupt. There was only one issue, and that was the trustee and the equity in house. And in the end, his good lady wife's family helped and contributed, and they settled with the trustee in bankruptcy at £60,000. So yes, there's the value there, but it's also what can be raised commercially versus protracted litigation, etc. So it's where we position. So every case is the same, but so different. Then there was the case where a gentleman, all he kept saying, I cannot go bankrupt, I cannot go bankrupt, I cannot go bankrupt. Cool. And over time, it transpired that this was more about his ego than the commerciality. And again, it's not nice. We're not saying, we used to do a part of our marketing campaign, being sort of Northern Irish based, was no one goes bankrupt for the crack. But in terms of commerciality, it brings a lot to the party. So it's how much do you need to protect your ego? In this instance, it was about £500,000 of shortfall over and above the debts to his assets that he was missing. So he had a portfolio, I think it was about 26 properties, mixed lenders. If it was one lender, you've nearly got a chance. But there was one lender in there particularly who was very litigious and would have mopped up the equity in the house anyway, and there would have been nothing you could do, and it would have been tricky for his wife, and they could have ultimately forced the sale anyway, so broad as it's long. So the properties bought, and they were in rough areas. They weren't in great places. They were city centres, cheap to buy, but he overpaid for them all, more or less across the board. Culminated in negative equity of about 900,000. And the pressure was coming on twofold. One portfolio was going from interest only to repayment, and one of them needed totally refinancing, which wasn't going to happen because the loan to value wasn't there. So he had a half share of his family home, which was about 400,000. A lovely house, beautiful house down in Berkshire, but he was still in debt and couldn't realise that 400 anyway. Eventually got over the fact that he might have to face a couple of people at the golf club, and they may look at him strange, but eventually petitioned for his own bankruptcy. And then we in turn then act and represent his good lady wife again in this instance, and she had the wherewithal to go and get 280,000. And we eventually settled that with the trustee in bankruptcy. And if you look at that 280 versus his 900, commercially he's saved himself over £620,000. So that's what we talk about, the commerciality. And there's a lot of this reticence to, I can't go bankrupt. I simply can't. My standing in the community. Nobody gives a monkeys. They might for a day and they might judge you, but people that judge you, don't worry about them. Okay, that's very, very important. So you get somebody who goes, I can't go bankrupt, right, well, it's going to cost you 100 grand to sort out. Okay, cool, I'll go bankrupt. So they say, it's not nice. We're not saying, oh, you'll feel so much better. Life just treats you brilliantly from there on in. It's tough, but if it was easy, everyone would do it. And then there's a slightly different tack where we got a ridiculous creditor here who was owed $750 on a personal guarantee, and basically gunned for him. And they were gunning for quite a few people in an area that we know quite well. And they would take no commercial representation whatsoever. They didn't care. They decided, I think they had about £10 million of exposure, 10 to 15 million pound of exposure. And someone in an ivory tower, somebody decided, we're not going into all that rubbish, just bankrupt them, right? Crazy. The trendy phrase at the minute, is it in the stakeholders' interest? And it undoubtedly wasn't. It seemed to be a situation where they really couldn't be bothered. They couldn't bother their arse to do a bit of work to maximise return for the stakeholders. And this was an elderly gentleman. They were at the value that he had 100 grand plus of equity in his house and business. And no matter what we did, no amount of reasoning would work with them. So they went through the Statute of Demand. That was basically indefensible, 750 guarantee, signed all day and correctly completed. The Statute of Demand came, it was correct, and then the Creditors Petition followed, but there was no talking to them. At the end of the day, a trustee was appointed in this case, and as we continued our investigations, which we do thoroughly, which we always do ourselves, we may be told a situation where a property is great and everything else. We undertook a couple of searches here at Land Registry, and it transpired the right of way wasn't quite right. In fact, wasn't right. So consequently, that had a detrimental value on the value of the property. We argued to and fro with the trustee, but at the end of the day, the property would have only been there and saleable really to a cash buyer. So that hit the equity position materially. We looked at the business and not a lot of assets. It was essentially two guys with a bit of a consultancy business, and there's a bit of cash in it, but then you've got the angry co-shareholder, 50-50 in it. He then bought the interests for $5,000, and this was part of a divorce as well, which made it horribly messy. But the ex-wife, God bless her, she raised £20,000, and we settled on an overall figure of 25. Now, the reason I'm slightly labouring this is it still galls me. See, it's not about the amount. We deal in cases where there are millions involved and everything else. Something's not right. We at Bell & Company don't care. This was wrong. And then what happened here was the cost in this case would undoubtedly have been totally absorbed, that 25,000 they secured from the ex-wife and her home versus the shares for the limited company. So 25,000 trustee costs. So the return for the shareholder, as I said there, was the square root of sod all. And well done that company. It's a big investment house who should have known better. I'm now a shareholder, and I will continue to be a pain in their backside in terms of the way they conduct themselves, because it was wrong, it was inhumane, it was malicious, it was personal, and just not an absolutely crap business. But these people in their ivory towers, don't get me started. So hopefully that gives you an insight of how we attack things. So you get the process, we get that. You've got to look at the involvement and every side of things. We have an area of work that we cover called pre-insolvency, and all it is making sure everybody understands the ramifications of it. We also give them the practical ramifications, the fact your bank account will be frozen. You need to establish, as that case there, example 3 there shows, have you got the title right? Is everything reflected as it should be? Because there are mistakes on title. Another issue that don't get me started on. But if it works to the advantage of the person that's ultimately got to buy the interest back, so be it. So we're going to end up on just a couple of points of reference, if you like. If you want to look at bankruptcy, your home, and anything else that's going on in the bankruptcy world, the official receiver runs it under the guise of the Insolvency Office, and there are various websites and landing pages, etc. they have prepared. If you're looking for confirmation or anything, that's quite good. If you're looking for commerciality, there won't be one iota of commerciality on it, and that's the same with our friends at the Citizens Advice. They will help and walk you through it, but they're not going to give you great advice right the way through. If you own nothing, they're perfect. If you have assets, then it's a little bit, they're slightly sat on the fence, whereas we always act for the client and make sure they get the best opportunity, best advice, the best opportunity. Citizens Advice Bureau give great advice on commercial debt and where people are and what they can and can't do. But we'd suggest this sort of stuff we're doing here is slightly beyond their remit. So I'm going to leave you with our contact details. with these webinars, we're imparting some of our knowledge. It's an information thing, if you like. Sure, we're a commercial organisation and we'd love to act for you, but if there are any specific inquiries, or any of my dear legal friends want to email me and say, Terry, you got that completely wrong, tell me, I'll impart that knowledge back out. But anything that stems specifically from this webinar, we'll entertain, and I will come back to you on a free basis. If you want to take it further, we'll talk candy further down the road. That's us. You're welcome to what we've got to say here. And I say it's difficult to get these things across because they're nearly conceptual. This has added a little bit of meat in terms of the process, but there's so much more. You know, the forms and how they're filled in and everything else. Sure, people can do it, but it's just don't get it wrong. That's all I implore you. Even if you don't use us, get somebody who knows what they're talking about and make sure they can cover all bases. And you're confident with that advice. That's very important. So thanks for your time. That's Bankruptcy, the Process. There's one more to come. I can't remember the title, but we'll come back to you. We had the fear, eradicating the fear of bankruptcy. Bit of a misnomer. This is a bit more on the process. You know where the route goes if, heaven forbid, you or an associate or a loved one has to go through this. Hopefully it gives you a little bit more insight to what goes on. Thanks for your time. Good luck.